Under the standard Pennsylvania rules, collecting a security deposit was straightforward. You confirmed the application, took the cash, signed the lease, and handed over the keys. But the Philadelphia City Council recently passed 2 laws that overwrite those standard business practices. These new mandates specifically target operators managing 3 or more rental units in the city. Holding properties in separate LLCs to stay under the 2-unit exemption, the city updated enforcement through ownership aggregation. It looks past individual business names, aggregating ownership to the actual people operating them. With 3 or more units total, you must comply. Failing to update your operations carries heavy financial penalties. The city classifies these violations as an unfair rental practice, entitling tenants to actual damages or statutory damages equal to a month's rent, plus attorney's fees. With the first law going into effect on December 2, 2025, there is no time left to figure out compliance on the fly. Operating rental properties in Philadelphia now requires running a high-stakes, highly regulated compliance system. The first major compliance deadline hits December 2, 2025, with the Security Deposit Installment Law. If you only charge a tenant 1 month's rent for a security deposit, your process stays the same. You can still collect that entire amount as a lump sum. If the first year's deposit exceeds 1 month's rent, the law requires an installment plan. The tenant pays 1 month's rent upfront. The remaining balance is divided into 3 equal monthly payments, paid over the 3 months following move-in. Your initial cash flow is now legally fragmented. You are effectively acting as a short-term, zero-interest lender for your tenant's security deposit. Once the tenant is moved in, you face the second piece of legislation, the Safe, Healthy Home Act, which takes effect November 1, 2026. This act gives tenants the right to request a certificate of rental suitability from their landlord once every 90 days. When a tenant makes that request, the clock starts ticking. You have exactly 10 days to provide that valid certificate. If you miss that window, you are legally barred from collecting rent until the certificate is delivered. There is a secondary, arguably more severe penalty regarding your right to remove a tenant. Under this act, you cannot file for eviction without attaching a certificate of rental suitability issued within 30 days of your filing date. If the certificate is missing, or if it is 31 days old, the eviction filing is automatically rejected. The court will dismiss the action outright, even if the tenant is months behind on rent and clearly in default. Your ability to collect rent and evict non-paying tenants now hinges entirely on continuous paperwork compliance. The physical assets you own in Philadelphia are now subject to strict regulatory oversight. Violating the deposit law triggers an unfair rental practice designation, forcing landlords to pay statutory damages equal to 1 month's rent plus legal fees. For the 2026 Safe Healthy Home Act, willful violations trigger an escalated penalty of triple damages. Furthermore, the statute of limitations for tenant claims has been expanded to 4 years. Practically, this means a simple paperwork error or missed deadline made in 2025 can legally haunt your portfolio and your bank account until 2029. Landlords must act now. Overhaul your lease agreements, establish reliable tracking for 90-day requests, and build automated installment systems well before December 2025. Professional property management provides the necessary compliance infrastructure to insulate an investment from these aggressive legislative traps.